So I'm going to start by saying hello and welcome to everybody from around Ontario. For people who don't know me, my name is Nat Paul. I'm OJEN's Director of Educator Support. This is the 5th of 6 webinars that we're running this summer, and we're really, really grateful to everyone who's made time to join us as a presenter or as an audience member. For you in the audience, with a teacher as a wife myself, I know exactly how up in the air your lives are right now, so I doubly appreciate taking time with us. As we get started, I'd like to acknowledge my colleague, Christy Pagnuti, who's working things behind the scenes. She's the lead organizer for this series and holding everything together as she always does. She'll be doing technical stuff while I deal with Q&A. We've also had amazing support from Michelle Thompson on both sides of the camera and from Rara Cesara, who has done all of the graphic design and always helps us look our best. As you know, today's session will be dealing with the way fertility is regulated. This is super timely as the lived experiences of trans folks and others who might not have access to conventional fertilization and pregnancy become more mainstream, and many of you teachers are going to recognize as well how these kinds of issues are affecting your own students if and when they deal with some of the social challenges around a non-binary identity. I hope you will join me in welcoming our speaker. Sara Cohen is an expert in the field who will be walking us through some of these questions and how they interact with the law here in Ontario. I'm going to say a little bit and then turn it over for her. Ms. Cohen worked in Bay Street litigation before setting out on her own in the field which she's passionate about, which is fertility law. This means representing clients who are intended or surrogate parents, egg, sperm, and embryo donors, and providing legal advice to organizations that engage with reproductive technologies. She's also served in numerous capacities in the community, including as a professor at Osgoode Hall Law School and providing leadership and representation for organizations like Canadian Fertility and Andrology Society and Fertility Matters Canada. Sara's been widely quoted in popular media and publishes regularly in scholarly publications, and has recently included in Canadian Lawyer Magazine's annual list of the top 25 most influential lawyers in Canada. A couple of housekeeping things. If you have questions or comments, please use the Q&A function. We're going to hold questions and comments for the end unless something desperately urgent comes up. If there are any links to be shared, we will post them in the chat. I'm going to remind everybody that the presentation is being recorded and we will post the video and PowerPoints to our website. Finally, as we've done throughout the series, I'd like to take a moment to acknowledge the traditional stewardship of the land that makes this meeting possible. Ontario is the traditional and contemporary home of a large and diverse Indigenous community. Where I live in Toronto, this includes the Mississaugas of the Credit First Nation, the Anishinaabe, the Haudenosaunee, and the Huron and Wendat people. To acknowledge this properly means acknowledging that this land was taken and that the taking was at times dishonest and violent. So a land acknowledgement is supposed to be an act of reconciliation. Reconciliation is more meaningful when it's specific and not a generic statement. So today, as we talk about issues surrounding parents and children, I think it's appropriate to acknowledge how breaking family ties and social bonds through practices like residential schooling and forced sterilization was actually part of the colonial practice of taking land. We often hear about intergenerational trauma, but of course, intergenerational trauma is always necessarily a trauma inflicted deeply and repeatedly through the disruption of family and social relations, the transfer of knowledge and the traditional relationships to land. I think many people would argue that the right to have children is one of the most fundamental of human rights, not just because of things like love and pressure from your mother-in-law, but also because it's how the reproduction of everything happens. So with that, I would like to turn it over to Sara. Welcome, Sara.
Thanks so much for having me. That was a beautiful introduction. I really appreciate it. And I think this is a lovely organization. I'm so pleased to be invited to speak to you today. Thank you for having me again. So I am going to go through my slides once I figure out how to get those working. There we go. And I only have about an hour with you today. So I'm going to be focusing on assisted reproductive technologies. And in particular, I'm going to focus on third-party reproduction. And when we talk about third-party reproduction, that's when we bring someone in to collaboratively family build, not on their own behalf, but on behalf of other people. So that in particular is about surrogacy and gamete donation. So gamete's a fancy word for eggs and sperm. You probably know that. Ova is another word for egg. If you're probably familiar with that too, just making sure everyone knows. We're not really going to spend a lot of time talking about embryo donation. It's done a lot less commonly in Canada, although it's something I'm quite passionate about, especially known embryo donation. And we're going to look at some case law. What I don't expect to have time today, and I don't have slides prepared for today, is to really talk about the laws of parentage. And those are different in every province. If I do have time, then at the end of the presentation, I'll talk to you today about some of the changes that have been made in the past few years in Ontario, about how a parent is recognized. And some of those are very, very exciting and something to be celebrated in Ontario. In particular, they've become really non-heteronormative for the most part, with very few exceptions, and very welcoming of children who are conceived through use of donor gametes in particular. So we can talk about that at the end if we have time. If we don't, I'm just going to focus on the laws across the country as they relate to surrogacy, gamete donation, and third-party reproduction as a whole. So people ask me all the time, what is fertility law? And it kind of doesn't fall exactly in one traditional category. It's a very niche practice, but it falls kind of in between, somewhere between family law, health law, but it also deals with a lot of other issues such as human rights, immigration issues, wills and estates issues, succession issues, etc. And that's where I see myself practicing. And fertility law, as a broad concept, answers some very important questions. It answers who is a parent, who is entitled to be a parent, which interests ought to come first. Do we ought to think about the best interests of the child, especially when that child hasn't even been conceived yet? Or do we think about the interests of the intended parents? And to be honest, they're the ones who are usually paying for the fertility treatments. Or are we thinking about the best interests of the donors or the surrogates and thinking about their vulnerability in the situation? It really has to balance somewhere between state intervention and reproductive freedoms. It has a lot of issues of consent that are a little bit different than other consent concepts we have when it comes to maybe other medical activities, and has a lot of ethical issues involved in it. So all of these things are very, very relevant when it comes to fertility law. So I'm going to look today for you at the legislative framework, which is actually the same right across the country. It's federal legislation. And the biggest piece of legislation that one needs to know when talking about fertility law is something called the Assisted Human Reproduction Act. That came into force in 2004 after tons and tons of debates and proposed legislation starting in about 1988. It took all the way till 2004. It is not perfect legislation. Something that happened in 2010 is we got a Supreme Court of Canada reference decision about aspects of the Assisted Human Reproduction Act, which actually found large swaths of that legislation to be ultra-virus. What that means is these were outside of the proper jurisdiction of the federal government and really should be under Ontario or other provincial governments and legislation. So in particular, things that have to do with matters of health and things that have to do with matters of parentage shouldn't be under federal jurisdiction and are really matters of provincial policy. So big, huge pieces of the legislation were struck down. But we have still some really relevant pieces of the Assisted Human Reproduction Act left. My personal opinion on this legislation is that it needs to be gotten rid of completely. And you'll probably hear a little bit why I feel that throughout this presentation. It's almost like string cheese. It's huge holes in the legislation that are just held together by thin little pieces. Now, under the Assisted Human Reproduction Act, for the last number of years, we've had regulations under the Section 8, so under Section 8, which is consent regulations, but there were two new pieces of regulation that came out in February and in June, respectively, of this past year. The first one, the Safety of Sperm and Ova Regulation, talks about using donor sperm and donor ova. And then the reimbursement related to assisted human reproduction regulations, that talks about reimbursing surrogates, reimbursing egg donors and sperm donors and embryo donors in Canada. And we'll look at those in quite a bit more detail. We're not going to spend a lot of time on the safety of sperm and ova regulations. It's very, very detailed and almost scientific. So not something we're going to spend a lot of time worrying about right now. So the way the Assisted Human Reproduction Act is set up, it has kind of lumps together some prohibited activities. And some of those prohibited activities include things like creating a human clone or transplanting a human clone, performing any procedure that ensures that an embryo is of a particular sex, except to prevent, diagnose, or treat a sex-linked disorder or disease, transplanting a sperm, ovum, or embryo or fetus of a non-human life into a human, or creating a chimera. And these that I've listed so far are not incredibly contentious. Generally, you know, people are okay with prohibiting people from creating human clones or transplanting a human clone or transplanting non-human life form into human, etc. However, grouped within that are also things like not paying consideration to a person to be a surrogate mother and not paying a sperm donor or an ovidonor for their donation. And I will talk about those in more detail as well. Other prohibited activities are making use of human reproductive material to create an embryo unless you have their written consent, and making use of an in vitro embryo unless you have the written consent of the donor. Section 8 goes through, you know what, I'm not going to actually spend too much time talking about Section 8 now because we're going to look at it when we talk about the case law at the end. But what I want you to be aware of is that other than Section 8, which is the consent regulations about basically what consent you need when you are creating an embryo or using an embryo, any of the other prohibitions I've just mentioned, including making a clone, but also including paying someone, you know, $20 for their sperm or $100 for their sperm, is guilty of an offense and it's punishable by up to 10 years in jail and or $500,000. I think that's, for me, at least, I still find that really hard to swallow, that we're having these kind of penalties when we're talking about compensating a sperm donor, compensating an egg donor, or compensating a surrogate. And I think a lot of people are surprised when they hear this. A breach of Section 8, on the other hand, the government, in its wisdom, took that out of, it made it not as highly, the offense isn't as high, the punishment isn't as severe if you breach Section 8 as it is those others, but it's still punishable up to 5 years in jail and or $250,000. And that part actually is looking at the doctors or the people who make the embryos or use the embryos for someone's reproductive purpose. So the doctors are actually quite scared about the Assisted Human Reproduction Act, because unlike typical medical processes or other medical processes where of course they have Healthcare Consent Act and they have lots of common law and other fiduciary obligations to their patient, there's actual criminal penalties and jail time if they get things wrong. And getting it right is actually extremely complicated. Another thing that is scary for pretty much anyone practicing in the area of third-party reproduction is that within the legislation itself, it says that the minister, so that's the Minister of Health, can notify any interested authority of the identity of a person charged with an offense under the Act, or who there are reasonable grounds to believe may have acted in breach of any professional code of conduct. So that goes right to the heart of people's ability to make their profession. So College of Nurses of Ontario, College of Physicians and Surgeons of Ontario, Law Society of Ontario, etc. And something that I think is important to think about is this proportionate? If you think it's an evil to pay someone for their sperm, I personally don't, but if you do think it's an evil to pay someone for their sperm, does it make sense that paying someone $100 is punishable by 10 years in jail and or $500,000, whereas advocating genocide is punishable by up to 5 years in jail, or driving impaired is punishable by up to 5 years in jail, fraud under 5,000 is punishable by up to 2 years in jail, obtaining the sexual services of a person under 18 is punishable by only up to 5 years in jail, etc. So I always think that's important to keep that in mind and think about proportionality. So the first piece of third-party reproduction that I'm going to spend some time talking to you about is surrogacy. And surrogacy is divided into two kinds of surrogacy. When you're reading the news and, you know, maybe you're reading People magazine or something like that, and you're reading about different stars engaged in surrogacy, they're generally talking about gestational surrogacy. So 9 times out of 10, or probably way more than that even, we're talking about gestational surrogacy. That is when the person who's carrying the fetus on behalf of someone else has no genetic connection to the fetus that they're carrying. So that has to be taken care of by IVF. Okay, and that's, you know, your typical surrogacy anywhere in Canada is gestational surrogacy. Another type of surrogacy is called traditional surrogacy. And that kind of surrogacy is where the person who's carrying the fetus on behalf of someone else does have a genetic connection to that fetus. So that could be done through insemination, or it could be done through IVF using that person's own ova. Okay? A lot of people think traditional surrogacy is illegal because a lot of people are less comfortable with traditional surrogacy. The idea of how could you give up a baby you are genetically related to that you've carried seems very uncomfortable for people. So they think traditional surrogacy is illegal. It's not illegal. And actually there's no parentage laws across the country that distinguish between gestational surrogacy and traditional surrogacy. My personal perspective is it should be perfectly legal, but there should be different requirements to make sure that this is not someone falsifying an adoption, but actually a proper surrogacy and is dealt with appropriately. So there should be distinguishing features between gestational surrogacy and traditional surrogacy at law on a provincial level, but there aren't. Nobody listens to me, unfortunately. I wish they did. Now, if you know nothing about fertility law in Canada, probably the only thing you do know is it's illegal to pay a surrogate. It's also illegal to offer to pay a surrogate or advertise that it will be paid. It's illegal for a doctor or anyone to counsel or induce a female person to become a surrogate or perform any medical procedure to make a female person a surrogate, knowing or having reason to believe that she is under 21 years of age. So we don't even want to talk to someone. A lot of times I get, clinics will call me up and they'll say, my patient who we've been working with and has had such terrible experience, their sister has offered me their surrogate. They're so caught up in the fact that it's altruistic and we're not paying the surrogate. We're completely sure about that. Yay, we found a surrogate, but they forget to think about the age requirement. You can't even be counseling her about surrogacy until she's at least 21 years or older. But the part that people don't talk about a lot that I think actually is maybe the most harmful is that it's also illegal to pay someone to arrange for the services of a surrogate mother or to accept consideration for arranging the services of a surrogate mother. And there's lots of problems with that. One is it's unclear. What is that? What is to arrange the services of a surrogate mother? It doesn't say to match someone with a surrogate mother. It doesn't say to introduce someone to a surrogate mother. And a little bit later in this presentation, we're going to look at the only case where this came into play. And we'll see that really, I don't think there's a lot of clarity on what this means. But the other thing about it is I like to think about adoption. And adoption, it is perfectly illegal, completely illegal to pay someone to adopt their baby. But at the same time, it's legal to pay an adoption agency to get the benefit of their knowledge, their expertise, and they can walk you through the process, help people find the social services they need, make sure everything's done properly. And we recognize the benefit of working with an adoption agency. We don't say, just go figure it out, do it yourself. But here, this legislation really makes it dicey working with a surrogacy agency, which for me is really a huge mistake in the legislation. Important to note though, there is no prohibition on accepting payment to be a surrogate mother. So the criminal activity is paying the surrogate, but not accepting consideration to be the surrogate mother. Now, although it's illegal to pay a surrogate, it has always been legal to reimburse a surrogate. And we've had this piece of legislation, which wasn't in force up until June, but now it's in force. And it always said that you can only reimburse a surrogate in accordance with the regulations, and that she has to provide receipts, and that if you're reimbursing her for loss of work-related income during a pregnancy, you must have a qualified medical practitioner certifying in writing that continuing to work poses a risk to her health or that of the embryo or fetus. So we didn't have regulations up until June about what was reimbursable, what wasn't reimbursable. And we were kind of left like, you know, with our arms up in the air, not sure what to do. And there were questions, and different lawyers had different opinions on what was reimbursable. So what I used, and what I think most people ended up using eventually, was a but-for test. So if the expense would have otherwise been incurred, you can't say it's as a result of the surrogacy, and therefore you can't reimburse it because she'd actually be benefiting financially from that. So I would include things like maternity clothing, travel to and from the clinic, and childcare, but not regular childcare, only childcare that was as a result of the surrogacy. You don't cover things like rent because she was going to pay rent anyways. You don't cover things like heating because she was going to pay things like heating anyways. But now we have these regulations, and the regulations gave us a list. And whoops, I went forward one. Now, Health Canada actually did a great job, I think, and they consulted across the country with fertility lawyers and other people who are involved in the world of surrogacy and said what should be reimbursable. And they gave us a list which looked a lot like the list we've been using, most of us have been using anyways, or at least I've been using anyways. So again, they're not covering things like rent, not covering things like heating or etc., your water bill, but travel to and from the clinic, counseling, legal counseling, dependent care. So that could be childcare. It could be if you have an elderly parent living with you, etc. One of the things they did is products or services that are recommended in writing by healthcare provider. And a lot of the surrogates I've spoken to find that very offensive. So if they are, I don't know, 8 months pregnant, and they say, I need help cleaning my house because I'm 8 months pregnant, they now have to get a doctor's note to do that. And it's actually not so easy to always get a doctor's note. It can be very time consuming. So just to be aware, it is absolutely mandatory now, and people definitely feel frustrated by that. But the big piece that was missing in this regulation is net lost wages in the postpartum phase. And that's a big problem for me because we understand, I think common people, general public understands that after you have a baby, you shouldn't probably be sending a surrogate back to work the next day. And if the entire point of the legislation originally was to protect women and children, and that's actually what's stated at Section 2 of the legislation, is that the entire point of this legislation is to protect women and children. How can you, by not reimbursing her for her net lost wages when she's in the postpartum phase and not allowing people to reimburse her without it being criminal activity, be watching out for the best interests and the health and well-being of that woman who's just been a surrogate? So Health Canada felt that they couldn't include that in the regulations because of statutory interpretation based on what was written in Section 12 sub 3. I'll show you again what that looks like over here, basically where it said otherwise the only mention of reimbursing loss of work-related income was during the pregnancy. They felt they couldn't then include it because this was after the pregnancy, although I think they probably could have just listed it, but again, I didn't get to make that decision. They included it in something called a guidance document, and that's actually quite confusing. This guidance document is written by Health Canada, and it says basically, this is how we, Health Canada, interpret this regulation that we drafted. And they said, we don't think it's a breach of Section 6 of the Act, which is the paying a surrogate, or Section 12 of the Act, which is the reimbursements, if you reimburse a surrogate for her lost wages in the postpartum phase. The problem is the guidance document does not have the force of law, whereas the regulations do. And as we saw before, breaching Section 12 of the Act is punishable by up to 5 years in jail and or $250,000 penalty. And breaching Section 6 of the Act is punishable by 10 years in jail and or $500,000 penalty. So these are, this is an example of why I think we have to go to the heart of the legislation itself. And if we have statutory interpretation issues with it, we have to actually amend the legislation, which is much more difficult than drafting regulations and even far more difficult than updating a guidance document. So the concept in Canada since 2004 has basically been womb mates and not wombs for rent. So we have altruistic surrogacy, not commercialized surrogacy. There is no payment for services and only for expenses incurred as a result of surrogacy. And people ask me all the time, well, what if I pay her outstanding debts for her, or I renovate her house for her, or I pay for her children to go to private school on her behalf? You can't hide a payment. It's still illegal, punishable by 10 years in jail and or $500,000. There must be receipts for all expenses, and they have to be related to the surrogacy. So another thing people ask me all the time is I draft contracts for surrogates, for surrogacy. And these contracts are quite long, they're usually about 40 pages long, and they say what goes in it. And in addition, the most important part is who is a parent and who's not a parent, and also those reimbursements, making sure they're all done legally and no one's going to get in trouble by accidentally breaking the law. we also talk about a lot of other issues. So really, whose body is it? As long as that fetus is in the surrogate's body, she gets to make calls. How do we deal with that when it comes to issues like abortion or selective reproduction when it's someone else's child? What about amniocentesis and other testing? How much of a say can the intended parents have on the lifestyle of the surrogate? Other things that we never want to happen, like what happens if the intended parents divorce or separate or pass away? And thank goodness I've never had intended parents pass away during the pregnancy, but I have had them separate or divorce during the pregnancy. And who does a child go to? Who is the parent of the child? These things have to be thought of in advance. Confidentiality. We live in a time of Facebook and Instagram and YouTube, etc. Are you allowed to document your surrogacy journey? Can you name the parents? Can you put up pictures? Can you put up pictures of your scans that you might want to share, forums? And one of the things that I find a lot of surrogates want included in this contract is the idea that what is our plan going forward? I'm going to do this for you. I'm willing to do it without, being compensated $30,000 or whatever number it could be. I want to know that when this is all said and done, you're not just going to walk out of my life. So what does that look like? Can we legally mandate that, or what kind of statement do we want to make in the agreement? And the idea here that really overrides the entire thing is there has to be a lot of respect. And that I work mostly for the intended parents, and I always tell them to put themselves in the shoes of the surrogate who's doing them the biggest favor you could do anyone in this lifetime, or one of the biggest favors that you can do for anyone in this lifetime, and think about how to respect her. And that really helps a lot. A question I get from the public frequently is, who is a surrogate mother? Like, who would choose to be a surrogate mother when you can't get paid? So there's some empirical evidence that came out of the University of Manitoba's law school by a professor named Karen Busby. And she looked and she found that most surrogates in Canada are Caucasian, Christian, in their late 20s and early 30s. Some are university educated. And generally people have modest but not low family incomes and are relatively stable financially, none on social assistance. Women of color are greatly underrepresented as surrogate mothers. And in a different study she did, Karen Busby compared surrogate profile in Canada to that in a place where we have compensated surrogacy like California, and another place where we have altruistic surrogacy like England, and she actually found that the profile is almost the exact same. It's almost identical. And I think that's when we're thinking about policy behind whether or not we should be permitting compensated surrogacy, we need to think about that profile, and does it make a difference about who chooses to be a surrogate within equal or relatively similar socioeconomic jurisdictions. So this is not the same as when we had surrogacy going on in India, where there were major socioeconomic distinction between the intended parent and the surrogate. Not the same as Thailand, Cambodia, Ukraine, etc., but much more similar to places like California, places like the UK. So the next part of my presentation is gamete donation. And like I said, gamete, fancy word for sperm and eggs. So retrieving sperm and retrieving eggs are clearly two very different processes. Much easier to retrieve sperm than it is to retrieve eggs, and much more risky to retrieve eggs. Despite that, under the legislation, they're dealt with completely the same. When I say the legislation, I mean both under the Assisted Human Reproduction Act and also under the Safety of Sperm and Ova regulation, even though in practice the experience is and the risk, is very, very different. Now, there's kind of a sliding scale in terms of types of donors. And on one end of the spectrum is an anonymous donor. And an anonymous donor is what I think that sounds like, which is someone you never are going to know who this donor is. You just are never going to know who they are. You have no right to know who they are. You're usually signing something that says you'll never try to find out, etc. And that's some people's comfort level. Canada tends to sway the other way though. And the other way is a known donor. And a known donor could be someone you know prior to going through the egg donation process or the sperm donation process, but it could also be someone you meet for the purposes of egg donation or sperm donation. And somewhere in the middle is something called open identification. And open identification is something that I think its heart is very much in the right place. The idea is you have an anonymous donor up until the time the child reaches the age of 18. At that point, the child, if they so choose, can reach out to this is only for banks, the egg bank or the sperm bank, and find out the identification of the donor. They may or may not be allowed to contact the donor, but they can find out that information. The problem with that is you're relying on a commercial sperm bank or egg bank to have that information, to still be open 20 years from now, and to have access to that donor, and etc. My personal comfort level is I'm a lot more comfortable with known donors, because not every child who grows up who was conceived through the use of donor gametes actually cares who the donor is, but some really do. And if you want to make sure that information is available to them, there's no governmental bodies right now that are responsible for holding on to that information for you. And if you're relying on a sperm bank or an egg bank, there may not exist 20 years from now. So that's concerning to me. Now, what does the Assisted Human Reproduction Act say about this? So it says that no person shall purchase, offer to purchase, or advertise for the purchase of sperm or ova from a donor or person acting on behalf of a donor. And the reason I have this end part here underlined is because it's actually not illegal, although it sounds like it is. It's not illegal to purchase eggs, and it's not illegal to purchase sperm. But it is illegal to purchase sperm or eggs from a person acting on behalf of a donor or the donor themselves. Okay? So why I explain this is because people will come to me and say, well, I thought you just said it's illegal to purchase sperm, but my friend purchased sperm from a sperm bank. And that's okay, because that sperm bank is not acting on behalf of the donor. You're not paying the donor. You're paying someone who already owns the sperm. So that's actually why in Canada, we import about 95% of our donor sperm. And we're now importing probably more than half of our donor eggs. And we're importing from jurisdictions where they're allowed to pay the donor. So I think this is all very hypocritical and very silly, actually, because at the end of the day, these donors are still being paid. They're just not being paid in Canada. So we have American donors who are donating their sperm, and then Canadian parents are buying from the sperm banks and importing it. In the same situation with donor egg banks have now come to be in the past 6 years or so. There is no prohibition on selling, so it's not illegal for a sperm donor to sell their sperm or an egg donor to sell their egg. Also different than Section 6 when we're dealing with surrogacy is there's no prohibition on payment to arrange for the services of a donor. So whereas there is a prohibition on paying someone to arrange the services of a surrogate mother, there's no prohibition on paying someone to arrange the services of a donor. Again, Section 8 talks about you need the consent of the donor in order to make use of the reproductive material to create an embryo. And that could be an in vivo embryo or an in vitro embryo. So it could be just using for insemination, or it could be actually through IVF. And also talks about an age requirement that someone has to be at least 18 to be a donor. Again, we have regulations that we didn't have before, but we always knew that we were allowed to reimburse a donor. We didn't know until June what we were allowed to reimburse them for. So very similar to what we had in the situation with surrogacy. We now have these regulations that tell us we can reimburse a donor for their travel, for dependent care, insurance, legal counseling, emotional counseling, etc. But again, we're missing any net lost wages, and we're missing that in any circumstance. And that's really problematic for me, because for a sperm donor to donate their sperm, they're probably, maybe they're missing 1 day of work. Maybe they're missing 2 days of work if they have to come back for certain screening requirements, etc. But for an egg donor, so say I'm doing a completely altruistic egg donation, and I live in Toronto, my clinic's in Toronto, most clinics in the country are in Toronto. There's something like 17 in the Greater Toronto area. But my sister lives in Thunder Bay, and I'm going to fly her in to Toronto to do the egg retrieval. Well, it's really not a good idea for me to stick her back on a plane and send her to work the next day. Again, that if the clinic is doing a good job, they're going to want to monitor her and make sure she's doing okay, both before the retrieval and after the retrieval. So I think she should be, without even compensating her, she should just be reimbursed and be put back in the same position she would have been in because she has to miss work. So the guidance document again deals with that. But as I said, for the surrogacy situation, the guidance document from my perspective is not good enough. This actually has to be the law, not just what Health Canada, which isn't the adjudicator's position is, but actually what the law is. It needs to be actually legal. So as I was mentioning before, we've had one case, and only one case, of anyone who's prosecuted under the Assisted Human Reproduction Act. And this was an egg donation agency and a surrogacy agency. So it was no parents have ever been prosecuted under the Assisted Human Reproduction Act, no surrogates, no donors, just an egg donation and surrogacy agency. And they pled guilty to 3 things, and I want to talk about this. They pled guilty to purchasing ova from donors. So they had no receipts, or the receipts didn't actually match what the amount was that they were reimbursed. So really they were compensating the donors. Same thing with surrogates. They didn't have receipts, or the receipts didn't match up to the numbers that were being compensated, that were being supposedly reimbursed, but really compensation to the surrogate. But the more important one from a legal perspective is this agency also pled guilty to accepting consideration for arranging for the services of a surrogate. But why this is so important is all of the charges in that regard were dropped against that agency when it came to Canadian surrogates, okay? The only time that they actually kept the charge and pled guilty was when they received a kickback from sending a Canadian intended parent to match with an American surrogate. And in that situation, there's actually a whole dramatic story behind it, where there was actually a baby selling ring going on in the United States and Ukraine, and I don't have time to get into it. It's definitely dramatic and very interesting. This agency allegedly didn't know anything about it, but what they did do is they sent Canadian intended parents to take over that surrogacy, but they didn't do anything else. So they didn't also provide services like introducing to lawyers. They didn't provide, psychosocial services. They didn't provide emotional support or any support of any kind. They just received something like $10,000 as a kickback, and that was seen as a breach. But why this is so important is because we understand that really when it comes to all of the Canadian surrogacies that they pled guilty to paying a surrogate for her services, they did not plead guilty to accepting consideration for arranging the services of a surrogate mother for the Canadian surrogacies, because we think what that means is it would be impossible or very difficult for the prosecution or the Crown to win on the idea that that you're accepting consideration for arranging the services of a surrogate mother when the agencies provide so much more than just that, and we don't know exactly what that means. But they're introducing to lawyers, they're introducing to counselors, they're providing psychosocial services, they're managing trust funds, etc. So at the end of the day, the surrogacy agencies continue to operate in Canada, and I personally think they need to be regulated, just the same way adoption agencies are, but they're in a gray area. We're unclear if they're legal or illegal, but they seem to be immune from prosecution, which kind of means they get to do whatever they want. Now, I've kind of already answered the slide. The other thing I do want to mention there is about the extraterritorial provisions. So the Assisted Human Reproduction Act is Canadian legislation, and it doesn't extend beyond Canada's borders. But what's important to understand is surrogacy, egg donation, sperm donation, fertility in general is incredibly transnational. So just because someone's doing something outside of Canada, if the payment's in Canada though, the Assisted Human Reproduction Act could be said to apply, because we see that's what happened in that case that I just discussed. So just because you're in the United States, don't think you're perfectly safe. It's important to talk to a lawyer and make sure that you have nothing that's connecting you to Canada. Now, I'm going to talk with you quickly about 3 recent or semi-recent cases in the fertility law sphere, that all of which I think are very interesting, that I want to share with you. The first is W in Genesis Fertility Center. And in this case, there was a husband who had sperm cryopreserved at a clinic, and he died intestate. He had no will, nothing. And as I kind of showed you, but I really ran through it very quickly, Section 8 says that you can use someone's sperm if they've provided their consent, and if they die, they have to have provided their consent in advance, that my spouse can use my sperm if I die. But in this situation, for whatever reason, the clinic didn't provide him with a sperm like this, and he didn't go and get legal advice about, if I die, can my wife use my sperm? So the wife wanted to be able to use the sperm and went to court to be able to use it, and the court held that there was evidence of repeated oral consent to the use of the sperm post-death, and that was enough. Even though the Assisted Human Reproduction Act requires written consent, they held this was enough. I don't have it up on the slide. I should have, my mistake, but there's actually a recent case law that goes the other way. So there's a recent case law that says, unfortunately, the Assisted Human Reproduction Act is a full answer to this. And if it's not in writing, it doesn't count. And it must be in writing and there must be that consent. It's important for people to be aware of that. Now, a more recent decision is SHDH. This one's really fascinating, I think. So there was a man and a woman who needed to use donor egg and donor sperm to conceive. I know that might sound to a lot of people like that's rare. It's not that rare. I see it all the time. They used donor sperm, donor egg. They had one child together. Right after that child was born, they divorced or separated. They had one embryo left over, and the woman wanted to use the embryo and the man wanted it destroyed. And the woman said, I'll use it, but I won't make you the parent. I'll just use it for me. And he still said, no, I have X, Y, and Z reasons why I don't want you to be allowed to use it. And the court looked to a consent form that was signed that said it's up to the woman if she's allowed to use it. And he appealed. And in the appeal, what he said, he actually relied again on the Section 8 consent regulations, which say that if the donor is a couple, the consent of each spouse or common law partner must be compatible in order for the consent of the donor to comply with the requirements of this part. And because they weren't compatible and he hadn't withdrawn his consent, it was not allowed to be used. So he got to stop her from using that embryo. And the final case I want to talk to you about is the Pratt case. This one's really interesting as well, or I think it's very interesting. There was a young woman named Olivia Pratt who was born in the early 80s, and she was conceived through the use of anonymously donated sperm, and she grew up knowing that. And she felt that she wanted to know who the donor was. So she went to the clinic and the doctor that had helped conceive her and said, I want to find out who the donor is. The clinic said, oh, I don't have the information anymore. The information's all been ripped up. It's been more than 7 years. It's gone. She then sued the British Columbia government and said, you have a duty to keep that information for me for when I reach the age of majority. So for anyone who's donor conceived, British Columbia, you have a duty that you owe to these children to make sure this information is available to us when we reach the age of majority so we can find out the identity of these donors. And she had the comparison group that she used, the comparator group, was adoptees. The same way that we owe a duty to adoptees to maintain information for them when they're older so they can find out the identity of their birth parents. So too, she felt, should donor conceived children have that right. And the lower court found in her favor. And they said that you are being discriminated against and you're right that you deserve that information. But this was overturned at the Court of Appeal. And what was said here is that what Ms. Pratt seeks is far more extensive than what is enjoyed by many people in Canada and would result in state intrusion into the lives of many. There are many non-donor offspring who do not know their family history or the identity of their biological father because of decisions taken by others because of the circumstances of their conception. For example, there is presently no law that compels a biological parent to share with the child whatever medical, social, or cultural information he or she may have concerning the other biological parent. I have about 1 minute where I'm going to talk to you quickly about parentage laws, and then we're going to go into question and answer period if there are any. So parentage law, the question of who is a parent depends completely on the province where the baby is born. So because I'm talking to the Law Foundation of Ontario, I'll talk to you about Ontario law. Ontario law at this point, in many ways, at least when it comes to gamete donation, is the best in the country. And this is because we had something called the All Families Are Equal Act, which modified or revised the Children's Law Reform Act, January 1st, 2017. And what it says is a few things. One, it allows multi-parent families. So it don't just have to have 2 parents. It can have 1 parent, can have 3 parents, can have 4 parents, etc. 2, it says a donor is not a parent, but we need to be clear who is a donor and who is a parent because we allow multi-parent families. So just because there's a donor doesn't mean they're not a parent. We have to make sure the donor, if someone's just a donor, if someone's a donor, they're just a donor, but we have to be clear who is a donor and who is a parent because we could allow all of them as parents together. One of the problems with it though is in a surrogacy situation, again, it doesn't distinguish between traditional surrogacy and gestational surrogacy, but it gives a surrogate 7 days before she's allowed to sign that she doesn't want to be a parent. And this is really problematic. And that's taken from adoption legislation. And the reality, the on-the-ground reality, is we have never, ever in Canada had a surrogate try to keep a baby. So in the interim, during those 7 days, the surrogate is now half responsible or has some responsibility for this child unless there's an agreement that says otherwise, but who's actually looking at the agreement? And the hospital where the baby was born is worried about about their liability, when really the surrogate doesn't even want to be a parent of the child. So it's unfortunate because I believe, as is done in the other provinces at this point, and as used to be done in Ontario, the surrogate should be able to sign away her interest in being a parent immediately upon the birth or shortly thereafter. That is the situation right now in Ontario. One other thing that's strange about Ontario law that I actually have more problems with and has caused quite a bit of controversy and some case law out of it is that we allow sperm donation through sex. It's the only jurisdiction in the world that I'm aware of that allows sperm donation through sex. So instead of just allowing in-clinic inseminations, instead of just allowing at-home inseminations, you can actually have insemination through sex as long as you have an agreement prior to the sexual intercourse about who's a parent and who's not a parent. And as you can well imagine, there's definitely been some case law where people say, oh, no, I was just a donor, and someone says, no, they were meant to be a parent and they owe child support. I'm ready for questions now if you are ready to give them to me.
There we are. I have lots and lots of questions, but I'm going to give a minute for people who are participating to get their thoughts together. I'm just sort of immediately struck by the sense that you started by saying sort of holes in the legislation. Like, I'm not sure if there's more holes or cheese at this point.
I think there's more holes, personally.
I think there's more holes. Okay.
My personal opinion on this, yes. My personal opinion is we need to redo it. And really, it shouldn't be criminal legislation when we're talking about creating families. I think this should all be dealt with, regulated on a provincial level, because these are health matters and parentage matters. And that's really what we're talking about. We're not talking about criminal activity, in my opinion.
Okay, so here's a question here. I'm going to paraphrase it a little bit. What differences are there between the way adoption scenarios versus surrogacy scenarios are regulated in terms of access to unknown parties, like an anonymous donor or whatever, how that kind of stuff? How does that work?
So surrogacy is never anonymous. You always know who the surrogate is. And in Ontario, you can't do, so I don't practice adoption law. There's not anything wrong with adoption. I think adoption is a beautiful thing. There's actually just not a lot of adoption work anymore. There's not a ton of adoptions that happen anymore in the province. So the actual, we don't have closed adoptions anymore in Ontario. They're all open. And that was Olivia Pratton's point, that we shouldn't have anonymous gamete donors. It is perfectly legal right now in Canada to have anonymously donated gamete donation. Questionable if that's a good idea or a bad idea. What would be lovely and what I would love to see is something we don't have, which is kind of what Olivia Pratton was getting at, which is a donor registry. I think every province should have a registry where they keep the identity and other health information that's relevant for this child about donors, and they could also share the information between the children who are conceived through the use of the same donor. So they could let another family know, oh, I know you use the same sperm donor. This child has this health issue that might be relevant for your health information. You could share that information. You could always also track how many times you're using the same donors, because we are using the same, especially sperm donors in Canada, we are using the same sperm so many times. We don't have any regulations that stop that. And I don't think we really can have regulations that limit that while we are restricting compensation, which means we have very few people willing to donate. We used to have something like 20 sperm banks in Canada, but when this new law came in 2004 that prohibited compensating sperm donors, we went down to one sperm bank in the country. So we have only one single sperm bank, and so 95% of our sperm is imported, but we use that one sperm bank again and again and again, and there's no regulation on how many times. So I think it would be great to stick a regulation on how many times. I think we should allow compensation, but we should have a donor registry that allows us to track how many times it's being used and track health information as well as identity.
And just this is actually my own sort of follow up of this. Would that imply, or is there already some mechanism in place where there's a requirement for an agency to be proactive if they learn of a health issue from a donor that was not known at the time, to relay that to recipients of that material, or people created by virtue of that material?
So, I mean, I think that would be great. There is something in the safety of sperm and ova regulations that talks a little bit about if accidents or omissions happen, to update people, like other people in the kind of in the train of users behind you or forward to you, to make sure everyone knows. There's actually no legislation that says you have an obligation to advise. I do think you could arguably be negligent though if you didn't. So we don't have any case law on that right now.
We have one from another from the Q&A here. Someone's asking, can you talk about why, from a policy perspective, we wouldn't want to allow people to pay donors or surrogates? The person has some guesses, but hear some of your insights. So
originally, if you look back to 1988, we had something called the Baird Commission, which looked into surrogacy and egg donation in particular. And they found that at the time they believed that, and I'm not sure they were accurate, because it seems to me there was a lot of ambiguity and a lot of ambivalence, but they believed that Canadians didn't want donors to be paid. There's a concern that you're inducing young people to donate their eggs when they don't know the risks. There could be medical risks involved that they might not know about. There's a concern that people would only give up the baby because of payment. The truth of the matter is, I think when we were drafting this legislation, there were concerns that haven't come to pass. And that's why I think it's so important to look at jurisdictions such as California. All over the United States, it's perfectly legal to pay an egg donor, pay a sperm donor. What does that look like there? Their financial or socioeconomic realities are similar to ours. And we find that these people are getting information they need. They're making educated choices. They have their own lawyer. They have their own counselor, their psychological counselor, who goes through it with them so they can understand the risks they're taking, whether they be emotional, mental, physical, health risks, and choosing to do this. I personally am not so sure that Canadians wouldn't agree to compensate a donor, especially when the results of not compensating a donor means we're just importing compensated gametes anyways from the United States. Mm-hmm. That's what's ended up happening anyways. And because of that, we can't really make a donor registry because we're compensating from the United States where we don't have the information. It's not the same as if we're donating here in Ontario. And if they were compensated, I think we could attract more donors here in Ontario. We could make that donor registry. But there's a huge follow through by the fact that we don't compensate and we have to import all of our gametes that I don't think people actually, I would like to believe some people would agree with me that it's much worse to not have access to that information for those children, not be able to restrict how many times we use donor gametes, etc., than it is to pay someone $100 for their sperm.
It's a whole new place for NIMBYism to go, isn't it?
Agreed.
Okay, so another question coming here is, and you may have touched on this, but it's probably, if one person's missed it, others have. A surrogate doesn't get a leave after delivering. Do parents?
So they both do, actually.
Oh, okay.
So yeah, she gets up to 17 weeks because she gets the maternity leave. So same with a woman who gives up a baby for adoption, she also gets a maternity leave, but the parents get the parental leave. So the parents get about 34 weeks and the surrogate gets about 17 weeks. But what I was talking about before is just because she gets it from her employer, they're required to give it to her, doesn't mean she might not pay into EI and then not get anything, or she might miss out on that top up that she should be entitled to, because we should want her to be able to, if the parents want to reimburse her for her lost wages, like I don't think she should financially be responsible for covering the cost of the surrogacy, and that's what ends up being if we're not allowed to reimburse her for her time after she gives birth and time that she needs to take off. I'm not sure if I answered that clearly. Did you follow? Or do I did. Try that again? Okay.
I did. I'm going to try and paraphrase this other question here because it's a bit wordy. So I think the question is, relating to sort of social trends, do you have any indication that greater sort of social prominence or more broad presence of folks who have different reproductive options, so trans women, for example, has increased the need for people who do the kind of work that you do, or the need for surrogacy more broadly, or anything in terms of the relationship between a culture which is maybe becoming a little bit more open and the kind of work you do?
Definitely. So I would say when I started doing this about 10 years ago, most of the people I saw were heteronormative. A lot of them were very embarrassed about needing surrogacy services, for example, and would talk about wearing things like fake stomachs. I never see that anymore. No one's talking about fake stomachs. I do see heteronormative couples still. Lots of single dads. I do see a number of transgender clients, and it might need, some of them need egg donation, some of them need surrogacy, lots of different needs within that community. Parentage used to be a big problem for people in transgender community, or especially two-mom families, but the Ontario new legislation has really kind of helped with that. You still need to take certain steps after you have a baby born through surrogacy, but you don't need to anymore if you're using a known donor, which we used to. It used to be more dangerous to use a known donor. It's not anymore in Ontario. Most of the people I see at this point are non-heteronormative. So there's a huge number of people who, for them, third-party reproduction is really like the way to build their family. And I'm so grateful that we're able to do this. It's such a beautiful thing. Like, for me, I think it's such a beautiful thing where we're able to help these people create their families. And it's gotten easier and easier in the sense that from a provincial level, it's gotten easier and easier to recognize these families. We have polyamorous families I see now, because we allow multi-parent families when you have an agreement in place prior to the conception. So I work with polyamorous families as well. Multi-parent families, so sometimes two different sets of parents come together and they want to build a family together. So I love this idea in Ontario, which is basically that it's the intention of who is a parent that makes them a parent. So you get to build your own family the way you want your family to look. I think that's amazing. Not every province is as progressive as we are, but I think the federal legislation, which is what I spoke about today, really gets in the way, and it still gets in the way.
I think we have one more question coming in from Q&A, and that will probably do it, unless there's something very urgent in the audience. So the question here is, reimbursing surrogates fairly costs a lot of money and is obviously crucial. Do you foresee a future where we are talking about access to surrogacy services for low-income people?
That's a great question. So I can tell you a few things. One is, in Ontario, the past number of years, we've had funded IVF cycle. If you're under 43, if you're surrogates in Ontario, you can get one funded IVF cycle. That helps a lot because IVF is extremely expensive. Another thing, though, is for lower income families, I see them go to traditional surrogacy, which is a little bit riskier, or at least it's thought of as being riskier, although we've never had a surrogate try to keep the baby even when it's traditional surrogate. But because a traditional surrogate doesn't require IVF, but just insemination, which can be done at home, lower income families usually or often will choose that route. But you're right, surrogacy itself, especially gestational surrogacy, is a fortune. It really is a lot of money. I don't know how to get around that because other than the ideas that I've thrown out here already, I don't really know how to get around that because you're right. You need to reimburse a surrogate. She shouldn't be out of pocket. Even in an altruistic situation, it shouldn't cost her anything to carry a baby. And I know people will say to me, well, it didn't cost me anything to be pregnant. Well, that's not true. It actually does cost you something to be pregnant. Yeah.
It does.
It does. It's very expensive.
Wow. Okay, I don't see anything else coming in. So with that, I think we'll call this one wrapped up. I'm so grateful to you for making your time to come and talk about this. It's super interesting. Yeah, we're getting people coming in now in the chat saying thanks. This was fascinating, and it really, really was. So just again, we will be making this recording available in the next couple of days. And all of these are going to be on our website. I'm going to remind people that the last session is tomorrow. Christy, what time is it?
1 p.m.
1 p.m. Okay. And this is just us talking about new resources and ways that we're hoping to deal with COVID with teachers over the next year. Sarah, thanks so much. That was lovely.
Thank you so much for having me.
Thank you for joining the OJEN family as well.
Great. It was great. Thank you for your time.
We're just going to let everybody find their way out.
Okay.
Thanks, everyone. See you later.
Bye-bye.